Start. These appeals are directed against the final judgment and order dated 10/12/2018 passed by the High Court of Delhi at New Delhi, whereby the High Court dismissed the application filed by the appellant herein. Stop. A few facts need mention herein below for the disposal of these appeals, which involve a short point. Stop. The appellant was a consumer of electricity. Stop. He, therefore, obtained one electricity connection from respondent number 2 BSES Rajdhani Power Limited bracket stat hereinafter referred to as BSES bracket close for its business premises. Stop. Respondent number 2 BSES sent a bill to the appellant for consumption of electricity to the tune of rupees 3,50,000 on 22/9/2014. Stop para. According to BSES, the appellant had committed theft of electricity and on it being detected, the bill in question was sent to the appellant. Stop. Since the appellant failed to pay the bill amount, the BSES filed FIR against him under section 135 of the Electricity Act, 2003 bracket stat hereinafter referred to as the Act bracket close, and sought the appellant's prosecution for commission of theft of electricity under the Act. Stop. It was also followed by notice under section 41 of the Criminal Procedure Code, 1973 bracket stat hereinafter referred to as the CRPC bracket close. Stop. The appellant and BSES, however, settled the matter in the special Lok Adalat held on 11/2/2018 for a total sum of rupees 1,60,000. Stop para. An order was accordingly passed by the Lok Adalat on 11/2/2018. Stop. According to the appellant, he has deposited the agreed amount in 2 installments. Stop. The appellant, therefore, filed a petition under section 482 of the CRPC in the High Court of Delhi, seeking therein for quashing of the FIR filed by the BSES against him in relation to the aforementioned dispute. Stop. By impugned order, the High Court dismissed the petition, which has given rise to filing of these appeals by way of special leave in this court by the appellant, the consumer. Stop para. Had Mr. V.K. Sharma, learned counsel for the appellant, and learned ASG for respondent number 1, and Mr. Sonal Jain, learned counsel for respondent number 2 BSES. Stop. Learned counsel for the appellant, referring to condition 3 of the order dated 11/2/2018 of the Lok Adalat, contended that in the light of the settlement arrived at between the parties, wherein the BSES has agreed to withdraw all the cases filed by them against the appellant, the FIR and the criminal case filed by BSES against him has to be disposed of in terms of the settlement arrived at in the Lok Adalat. Stop para. In reply, learned counsel appearing for respondent number 2 BSES contended that the issue in question has to be decided keeping in view the requirements of section 152 of the Act. Stop. Having heard the learned counsel for the parties and on perusal of the record of the case, we are inclined to allow the appeals, and while setting aside the impugned order, remand the case to the High Court for deciding the petition afresh, keeping in view the provisions of section 152 of the Act. Stop. As rightly pointed out by learned ASG appearing for respondent number 1, the issue in question needs to be decided in the light of section 152 of the Act, which deals with compounding of offences under the Act, stop para. Since we find that the High Court did not examine the issue in the light of section 152 of the Act, we consider it proper to remand the case to the High Court to examine the issue afresh, keeping in view the provisions of section 152 of the Act, and then pass appropriate orders as the case may require on the facts involved therein in accordance with law. Stop.